Hi, everyone. Harry here to talk about the Supreme Court in its second day back, handling the first sort of high-profile headline case. It's a case from Colorado, and it involves therapy to potentially try to change a young person's conviction about their gender identity. It's brought by a therapist who has a religious orientation, and she says that Colorado's law prevents her from free speech. So let me lay it out a little bit more. Colorado's law says, citing a whole bunch of medical studies and the like, you may not try to change a young person's perceived gender identity. They come to you and say that they feel very much like they're a male in a female's body or vice versa. Colorado says you can actually pursue conversion therapy, which would permit that minor with hormone treatment and the like to change their gender, but you can't do an attempt to change gender identity, basically in this case, to talk them out of it. Now, the plaintiff is someone who is avowedly religious, and I think comes at this from the point of view that there's something you could say sinful about wanting to change your identity, or you could just say God-given, or to be encouraged to fight the urge to change your identity. Colorado, along with 20 other states, has passed a statute based on the medical record, which, as they say it, is actually, there's a fair bit of controversy in the case, even as it comes up to the Supreme Court, oddly, because that's the sort of thing that should have been all worked out below. But Colorado says medical professionals are really unanimous that trying to basically talk someone out of it or push against them and say, no, embrace your current identity, don't try to change it, is really deleterious. We're talking about, a window of possible treatment that when it closes post-puberty, the die is cast, as it were, and the medical evidence seems to be, I'll get back to that, but seems to be that young people who are prevented from undergoing some kind of conversion therapy have terrible outcomes of depression and suicide and the like. So one way to look at the Colorado law, imagine there's a therapist who's urging people to, undertake prayer for cancer, or to avoid vaccines for religious purposes or the like. The state is coming in, again, 20 states have done the same, saying you can't do that because it doesn't accord with the standard of care that medical professionals need to have. You can't recommend Latril for lung cancer. It's about the efficacy of the therapy and actually the prospect that the therapy leads to really serious consequences once young people complete puberty. The plaintiff is, as I mentioned, comes from a religious orientation, and she'll get referrals. So a young person may go to their pastor and say, I've got these really strong feelings that I'm the wrong gender and I want to change. And they are referred to this person, and she, in therapy, basically tries to persuade them to stay with the gender that they were born with, and we don't know the particulars of the therapy, but that's what they do. Okay. Now comes the doctrinal question that is at the heart of the case, which is this therapy conduct or speech? You can see it both ways, right? So the therapist is saying, I sit down with them. I talk with them. That's what I do. I talk with them. That is First Amendment protected speech. And there's sort of two questions at stake here. And one is it speech or is it conduct? The conduct of trying to not dissuade, right? The conduct of therapy designed to prevent a conversion, or is it just speech having a certain viewpoint? So, and it is right. Justice Kagan said at oral argument, if you're a licensed therapist, that's your point of view. It's a religious point of view. Somebody comes in your door and you say, you want to give them therapy to make them satisfied with their current gender. And then they go the next door and the person there wants to help them change their gender. Seems like just a difference in viewpoint. But under Colorado's law, the second one is okay and the first one is not. But the question is, A, is that really conduct or is it speech? It's words, but a lot of conduct consists of words. And then second, is there some lesser standard for words uttered by a professional and that's licensed by the state? It's basically has to do with that category and whether it would be carved out. The court previously has indicated that it's not lesser protection, that if your, professional speech is the same as political speech is the same as artistic speech, it's all protected by the First Amendment. Okay. Now we have everything set up with one more point. You may remember a few months ago, the Skermetti case in which the court, or the hyper-conservative majority of the Roberts Court, said Tennessee can impose a law that prohibits conversion therapy. So it's a particular kind of therapy. They said they can prohibit it. Colorado says, we're doing the same. We're prohibiting it. In Tennessee, they had a judgment that seemed very much infused with and influenced by religion. They say, Colorado, this is a straight up medical determination. All the professional organizations say this therapy harms minors, maybe grievously. That's what we want to take off the table. You can imagine this, it used to be like this until 40, 50 years ago. Homosexuality was actually regulated or considered under the psychological literature as a pathology. And at the time, you might have said, well, if you can't try, or you could try whatever to have, there were efforts then that we consider pretty brutal and antediluvian to talk people out of it, as it were. Okay. Let me just now zero in. So the number one issue you're going to hear about, and the case will probably divide on the issue of, is this straight up speech? The 10th Circuit, by the way, and the district court below said, even if it's not, it's conduct, therefore we can evaluate it under a lower scrutiny, rational basis, where you just have to find there's some rational basis for doing it. And they upheld the Colorado law. Same thing with the district court. And they said, we're not going to enjoin Colorado from going forward and doing it. And it's at that posture, the request for preliminary injunction, that it goes to the Supreme Court, which is, heard arguments today. So just to touch a little bit on different questions, you had the United States come in and say it's pure speech. This is just like regulating political opinion or viewpoint and the like, strict scrutiny. And you may remember the old saw, strict in theory, fatal in fact. If indeed the court says this is regulation of speech, pure and simple, very likely it sends it back to the 10th Circuit. The 10th Circuit considers that very stringent test and says that the Colorado law under strict scrutiny can't be used to keep the therapist, the religious-based therapist, from giving her counseling, not to undergo any kind of gender identity treatments. Okay. A big part, as I mentioned, and it's curious, but especially Justice Barrett, was trying to understand what is the medical record here. And the Colorado said there is no record of success for the sort of therapy that the religious person is doing. The idea of, talking people out of their gender dysphoria. And indeed, there's a record of terrible results, as I said, of depression and suicide and the like. No record of success of what this plaintiff wants to do has any prospect of actually working, and instead it leads to terrible results. Justice Jackson, I'll just mention, she was on the Tennessee point that I just said. It would seem awful strange, she said, if this court would say Tennessee could ban conversion therapy based on their view, but Colorado couldn't do the same. And then basically it had there was a lot of back and forth that just has to do, are they regulating speech or are they regulating content? And, Colorado in there saying, look, this is just, it's the same as telling a licensed provider that they can't use leeches. Or I guess you could say they can't talk about how great leeches are and the like. It's just a standard of care case. One final point, there is a wrinkle of standing in the case. The courts below found that the religious counselor had standing, but in fact, there's Colorado disputes that. They said, look, we've never come after her, or there's no record that what she has said is, I want to be able to counsel this way. Okay, so she wants to be able, and there's no record that Colorado has ever tried to stop her and the like, so they should throw out the case for lack of standing. That's a little bit of an aside. The basic notion: can a state say, don't do this for medical reasons, and if this includes basically, or even consists basically of speech, is that subject then to strict scrutiny? If the court finds that it is, they likely, as I say, remand, ask the 10th Circuit to consider in the first instance, but it will probably almost certainly lead to striking down the law as it applies to this person. And with the sort of anomalous result that, that certain... You can say what happens in both Skermeti and here is the religious person, or the religious viewpoint prevails in Skermeti. The idea that you shouldn't ever do this kind of therapy. Chief Justice Roberts says for the court, everything's all roiled and in dispute. We better let the people take care of this, by which he means the legislature, and ordering doctors and patients and young people what they can consider. And then here it might turn out that, but there's a First Amendment right for talk therapy. That's what she does. She, we don't have the transcript, but she, talks it through and tries to persuade young people not to, to accept their birth identity. And so that would be a free speech right. And yet what a kind of strange state of affairs if in both instances, essentially the Christian line, that's just, as a matter of fact, what it is, would prevail, even though it seems like contrary results. Wait for a while on this one. It'll be controversial, although, the supermajority may, really just bowl through, but it'll be a few months in any event, maybe even more, until we get the opinion in the case. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.